Yes, Your Honor. Just a couple on page 7. The second paragraph down, for you to find the defendant guilty of first-degree murder of Lyric Woods, the state must prove 6 things beyond a reasonable doubt. That's the self-defense language. It should be 5. Also on page 8, in the last paragraph, the first sentence, acting with malice and not in self-defense, the self-defense language should be removed.
And I apologize. So fourth element, fifth element,
Then premeditation, deliberation, then the next paragraph.
if you find.
If you find at the end of the second line, acting with malice and not in self-defense. And then my only other thing was a question or a suggestion. Because there's self-defense with regard to one victim and not the other, would it make sense to separate the final mandates by victim so that it's clear that those lesser includeds are not an option for Lyric?
Wounded the victim, Lyric Woods. I think that would be the final.
I do see that. In that case, then I would suggest that we replace victim with Devin Clark in the second set of final mandates.
Mr. Trout, that probably is a good suggestion.
Your Honor, I agree with what Ms. Orr said. I found the original changes, and I agree with that second one, just so it's completely clear what the final mandate is, and it's clear in the jury instruction, but just so that they have the instructions right.
Okay, I will go through and put Mr. Wood's name in that final mandate so it's clear. Clark. Clearly need more caffeine at lunch. Yes, ma'am. Trapp, you getting what you need? Well, when we finally agree on everything, but that's just to go in that notebook with the jury. Anything else?
I just have a couple that I had pulled out that I need to give Mr. Trapp.
It's nice of you to do that, Mr. Trapp.
I do not have 29.
Would have been helpful, Mr. Trapp, if you'd let the clerk know that you needed these exhibits so she could have pulled them over lunch. So let's make sure you get everything you want now. While we're waiting on that, do you have any, Mr. Trapp, suggestions for changes or alterations to the jury instructions?
Thank you for asking, Judge. The 2 or 3 that were initially brought up by Ms. Orr were the ones that I saw, but no other additional ones.
And other than the objections you've already raised, you have no additional objections to anything that is in the jury instructions?
No, Your Honor, I do not.
Are you sure you have 29? I do not have it.
There are non-slots. Okay.
Paige, I'm sending you right now. Would you print the 2 copies for each of them? Madam Clerk, do you know what they're looking for? Hmm? evidence to use during the closing. I want everybody to have everything that they need. So, Ms. Orr, are you good? You're gonna need to get some, I realize, when the defendant is done.
Yes, Your Honor, but I have everything else I need.
Okay. All right. Mr. Trapp, do you believe that you have everything that you want out of the evidence group?
Yes, Your Honor, I do.
All right. So as to the verdict sheets, there are two verdict sheets. One is regarding the charges involving Ms. Woods. The second one is the charges involving Mr. Clark. Does anybody object to how they look or how they are worded? Ms. Orr?
No objection, Your Honor. Thank you.
No objection, Your Honor, they're very clear.
Okay, we will use those. Okay. Give us just 1 second. We'll print off copy for each side, the final jury instructions. I will remove all of the headers and any remaining footnotes for the ones that are sent back to the jury. I will send that clean copy back to the jury with the verdict sheets. All right. Do you need a couple minutes to look through the instructions again?
If you don't mind, Judge.
All right, does anybody need any more time?
No, Your Honor.
No, Your Honor, thank you.
Any further requests for changes, additions, or deletions other than the already preserved objections of the defendant
No, Your Honor.
Nothing from the defense.
and the state? Sorry. All right, then are you ready to go, Mr. Trapp?
I am, so I'm gonna attempt to do PowerPoint. Hopefully my technology works. And-
Bring it up right now so we can see what we have before we bring the jury in.
All right. Is math.
This is blank. Okay. What's your screen look like? Okay. Make sure you can go back and forth. Okay. All right, anything else you need to set up before we bring the jury in, Mr. Trout? Perfect. All right, anything else, Ms. Orr?
No, Your Honor, just if, Mr. Trapper, you're gonna be writing on this board?
If you need to move so you can see, then please do. Just
Thank you.
don't stand in the way of the jury.
And if you want, I'm gonna set it up kind of over there in the corner. So
Okay.
yeah, you can go now.
See if I can see it from here, and if not, I'll go back there.
Can you see the PowerPoint?
I can see the PowerPoint there and there.
Okay.
And I will look around Miss Kimball's head. Yes. No. Yes. Thank you.
All right, I think we're good. Let's go ahead and bring our jury in. The main screen has not worked the whole trial. There apparently is a request from the facility management to come and try to fix that. I have also put in my 2 cents that I would like them to do it. They have not responded yet. So outside of start hauling people in here and threatening them, there's not much else we can do. So it is clear for the record, though, there's a television at the end of the jury box that the jury can see. So everybody in the box should be able to see both the state and the defense's visual presentations during their closings.
That's correct, Judge.
we've got all our jurors back in the courtroom. See everybody. So at this time, as I mentioned earlier, you have heard all the evidence that is going to be presented in this trial. At this time, the attorneys are going to be presenting closing arguments. Just remember my earlier instructions, much like opening statements, closing arguments are not evidence, but to assist you in evaluating the evidence. So with that, Mr. Trapp, the jury is with you.
Thank you, Judge. Ladies and gentlemen of the jury, we have spent this last week, a couple days, listening to evidence. Both the state and myself got up at opening and we talked about what we would see. We talked about what you would hear. And it was our expectation that you would hear the facts necessary to make a determination. But now we're at the close of it, and you're going to hear from both myself and Ms. Orr on an understanding or interpretation of what you experienced. This matter that we're here for, it's nothing short of tragedy. We have two young kids that lost their lives. We have another young man who is facing one of the most serious punishments in our criminal justice system. There are no winners in this situation. None. All of us were teenagers once. All of us made bad decisions, snuck out, broke the rules, but it didn't have such a serious consequence. All of these individuals should have followed the rules. Should have been home. And now we're here today to talk about the conduct that occurred. After Mr. Ross got off the witness stand, he spoke to you about what happened on September the 18th. He described to you the idea that he was fighting for his life, that he was put in harm's way, that he was staring at the end of a barrel of a gun, not knowing if he was going to see his next decade. The judge is going to give each of you a set of instructions. I'm going to talk about those instructions. The state is going to talk about those instructions. But these instructions are like your roadmap. These are the things that you are going to follow in order to make a determination on Mr. Ross's innocence or guilt. The charges that he has in front of him are first-degree murder. That is the unlawful, intentional killing of a human being with malice, premeditation, deliberation, and of course we will include with a deadly weapon. Now, malice is the unlawful taking of the life of another without, I repeat, without justification or excuse. Second-degree murder is the unlawful, intentional killing of a human being with malice, but without premeditation and deliberation. Now, premeditation, a person must form that intent to kill over some period of time. Not instantaneously, but more like a plan. And lastly, voluntary manslaughter, the intentional killing of a human being without malice and did not act in self-defense or they used excessive force. Now, the definition for deliberation which goes back to second degree or first degree, that person acted while the defendant was in a cool state of mind. The evidence that we have heard from the experts to the officers to lay witnesses to Mr. Ross himself, it is clear that what happened on September the 17th was not planned. It was not premeditated. There was no time to deliberate. This was supposed to be a Saturday getaway where these individuals were going to have sex. That's what the plan was. And everything went the wrong direction. Now, when we're making these decisions, when we're going through all of these elements, we have to talk about an important topic. And that important topic is reasonable doubt. It's on every movie, every TV, but it's one of those words that you can't necessarily grasp. Almost like the word love, if you were to define it. What does it mean? What does it look like? How does it fit into this justice system as we decide on each one of these elements? Now, the judge is going to give you an instruction, and that instruction is going to say a reasonable doubt is a doubt based on reason and common sense, arising out of some or all of the evidence that's been presented, or lack or sufficiency thereof. Proof beyond a reasonable doubt is proof that fully satisfies and convinces you of the defendant's guilt. Fully. Now, when I first started learning about this concept, I needed a visual, kind of comprehend and grasp what this really means in the gravity of it. And so, this illustration should help. I want you to imagine that this is a mouse. I put this mouse in this box with a piece of cheese. A couple seconds later, I open up this box. The mouse is here, but the cheese is gone. It is simple. The mouse ate the cheese. But if I put this mouse back in this box, and I introduce a cat. And when I close the box starts to shake. And I open the box back up, and the mouse is gone. The question is, what happened to the mouse? Your immediate response is going to be obvious. The mouse ate the cheese, the cat ate the mouse. But if I told you, on the back of this box, there's a hole just small enough for the mouse to get out. That is reasonable doubt. And so when you are sitting and looking at the state's evidence and looking at the idea of first-degree murder, second-degree murder, voluntary manslaughter, and also self-defense, it is the state's job to prove every element beyond a reasonable doubt. Every one of them. Just like this mouse could have, and would have, and should have gotten out of that hole. That is what you're looking at. Self-defense. That has been talked about a lot in this case. It is an idea that exists in most people's minds. The idea that an individual who is in danger, in fear of their life, presented with few options but to defend themselves. Now, this case started out with a picture of two individuals laying in a secluded road. They were positioned in a way with multiple gunshot wounds. At first blush, there was no understanding, no expectation that self-defense was even an option. the evidence progressed, and we started looking at the fact that there was only one firearm, the expert from the state made that clear. All these shell casings had the same tool marks. But then we further got more information that that firearm was a 9mm, and that same day or shortly thereafter, a 9mm gun belonging to one of the victim's fathers was missing. It was not a coincidence that gun was missing. That firearm was brought to the scene by Devin. Even before Mr. Ross testified, that was the idea, that was the thinking. Even from the investigator, when he got on the scene, he believed that Devin Clark's father's gun was used in the commission of this act. So one question may be, why, if these kids were just going to have sex, would Devin bring his father's gun? But then more importantly, why would Issiah Ross, who knows Devin to an extent but doesn't know lyric, have any issue with either one of them? But Mr. Clark, according to Mr. Ross's testimony, had some heated conversation with Lyric Woods. So much so that he took this gun that he brought and shot Lyric. And then he took that same gun and turned it on Mr. Ross. So then the question is, if an individual who has already shot someone turns a gun on you and points it in your face and threatens to do the same thing to you, does that meet that point? Meet that point of self-defense? I submit when you get your instructions from the judge and you put all these facts together, it will be clear. Now, Mr. Ross, on September the 17th, 2022, was a 17-year-old high schooler at Eastern Alamance High School. As we just talked about, he had a gun pointed at him. He was unarmed. In this altercation, and this was discussed by the medical examiner, Mr. Clark had an abrasion on his lip as well as on his ribs. He busted Devin's lip during the struggle. Devin had multiple gunshot wounds, but he had one in the front by the chest. He had another in the front on his foot. And then he had 4 others that came around the back. When Issiah was on the witness stand testifying, after he struggled and got the gun, he fired. Bang, 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 bang. Witness James Rogers, whose house is right across the street, described the shooting. He said first he was awoken. What he didn't know what it was, but he had heard something, a bang, fireworks, the like. Started to go back to sleep, but then he heard a succession of 5 shots. Bang, 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 one after the other. This was not a stop and wait situation. This was an immediate reaction to an immediate threat. Mr. Ross testified. He said, I was scared, I was shocked, I didn't know what to do. He was in fear of flight. I asked Mr. Ross, what about Devin? What was his stature? What was his size compared to you? He mentioned he was about 6'1", 6'2", 200 plus pounds. Mr. Ross, he's not even breaking 150. So we have a bigger, stronger individual with a gun who's just shot and killed someone, pointing a gun at him. And then the next question is motive. Motive is going to be one of those rules that the judge is going to bring to your attention. And we had talked about that a little bit at jury selection. And the judge is gonna say that the proof of motive for the crime is permissible, often valuable, but it's never essential for conviction. If you are convinced beyond a reasonable doubt that a defendant committed the crime, the presence or absence of motive is immaterial. It may be shown by facts surrounding the act if they support a reasonable inference. But when you all are piecing together this story, trying to figure out, has the state satisfied your questions? Have they satisfied you beyond a reasonable doubt that Issiah Ross killed Devin Clark and killed Derek Woods? This is going to keep coming back. It's going to keep coming back in the idea, well, what happened? Because there's still no clear story of what happened. Now, here are a list of all the witnesses who testified. First, we had Joseph Kaiser and Jordan Wilson. Those were the two individuals on the four-wheeler who located the bodies on the 18th when they were going to check their cameras for the deer cameras in the woods. And they said that this was their first time, they had never hunted this area before, and that before they even got there, first it was Joseph, he saw the bodies and he made like a shriek, and then Jordan saw it, and as soon as he saw it, they hightailed out of there. We have Elizabeth Kennedy, that is their mother. Dexter Clark, that's Devin's father. They testified about the last moments when they saw their children and their responses to what happened once they got this information. And then our first officer to testify was Officer Suzanne. Now, Officer Suzanne was one of the ones to first get on scene, and I think you remember that he was the witness who at first said, oh, I think I might have driven on the scene, and then they put a body cam up, and that body camera footage showed that he hadn't actually driven on the scene. He stopped just before he got to the rock roads. Investigator Baldwin, he is their evidence tech. He's the guy, when he got there, he put down all the placards, located the evidence, packaged it up, and he's the one, whenever evidence was found, they would turn it into him. James Rogers. James Rogers is the individual who lives right across the street. I just mentioned to you, he was the one who heard the shots. He was going to the beach the next day. He did tell his son about it, and I believe law enforcement contacted his son, and then he let law enforcement know that his dad had told him about these shots, which gives us the timing of these shots. Just before 2 and shortly after 2 a.m. on the 17th. Dr. Lauren Scott, she was the one who did the autopsy. And she was the one who did the exams of both Lyric and Devin, and showed you the wounds, explained to you the cause and manner of death. Walter Villa, another officer with Orange County Sheriff's Office. He mentioned that he was on scene on the 18th, but he was the one who got a call that there was a phone cord that may be at the scene, but when he got there, never found the phone cord, but found that last shell casing. Now, Jeff Bray, we'll come back to him. Dawn Hunter, she was the one who interviewed Mr. Sykes. She was on scene on the 18th, and she gave a little bit more description of what the bodies looked like and how they're positioned. But she was the one who called Christian Sykes and met with him in the Walmart parking lot. Now, Kyle Borland, another officer, he was the individual who went to the house and made sure that the car got towed back to the location. Antoine Bryant. Antoine Bryant is the ex-boyfriend / stepdad / caretaker for Issiah Ross. He got up on the witness stand, he talked about his relationship with Isaiah, the fact that when Isaiah's mom first got angry with him, he took him in, let him stay in his house, fed him, even took him to the bus station, and all the while encouraged him, hey, Isaiah, just whatever you do, make sure you finish. You know, act right, do right by your mom, apologize. He talked about how he noticed the damage in the front of the car. He picked Isaiah up, he took him back to his house. That afternoon, they got back around 3:30, and Isaiah just stayed at his house until it was time to go. Now, why is that important? Well, we'll go down a couple people. Christian Sykes got up on the witness stand. And when he first got on the witness stand, he didn't remember much. He kind of understood, but said it was too long, too much time. And then the state played his interview, the interview he had with investigator Hunter. And he was talking about how he got a call, or he talked to him, I should say. He reached out to Isaiah, and that they met up Saturday the 17th when he got off work and smoked. And one of the jury instructions is going to deal with credibility of witnesses. And that you all are supposed to bring your own common sense and normal understanding of daily life to determine the credibility of each witness. What are they telling me? Is it true? Is what they're saying believable? And what skills and what things to use to determine that? Well, one thing you look at is, are there some things that they're telling you that just don't match up? So one is, they did not get together on Saturday the 17th, because time-wise, it doesn't match up. Mr. Bryant said that he took Mr. Ross to his house. Mr. Ross said that. Another fact is that when Mr. Sykes was on the witness stand, he said that this altercation, this shooting, took place in the car. You've had a chance to see the evidence. You've had a chance to see this white GMC Acadia. There were no shots in the car. There were no bullet holes. And according to the state's own expert, there was no blood in the car. Now there is a person. His name was Solomon. He was considered one of the wisest individuals to ever walk the earth. And story says that he had a visit with the Spirit or God. And he was asked, I'll give you anything you want. And he asked for wisdom. Shortly thereafter, he was presented with an issue where two women were arguing over a child. They were claiming that that child was theirs. Well, the backstory is that one of the women had a child and lost it. So she proceeded to take this other woman's child while she was sleeping. And so Solomon stopped, and he listened. Both of these women claim, this child is mine, this child is mine. And finally, Solomon said to one of his soldiers, give me your sword. I'm going to cut this baby in half, and you can each have it. And at that instant, the mother said, no, 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 stop, don't do that. You can give her the child. And at that moment, Solomon knew who the mother was. Because no mother would want to sacrifice it. And so when you use your wisdom, when you use your common sense to look at this evidence, think about what people say. Think about how they say it. Think about how things just don't add up. They don't match up. Now, we had different experts get up. Phoebe, Wendell Ivory. Mr. Ivory, he had several reports by the crime lab. They were introduced into evidence. There were DNA swabs, and these DNA swabs were of different parts of the vehicle. He tested the underwear, he tested people's hair to look to see where were they present. Wendell Ivory, from his DNA evidence, made it pretty clear that Lyric and Devin had sex that day, which is what Mr. Ross testified to, which is what even those text messages at the very beginning through Snapchat, you guys verified. It was clear that happened. You could see in the back of the vehicle, Lyric's DNA was on the back door handle. The back door handle that she came in through and she went out of right before that shot. When you are looking at these facts and comparing what the state's theory is to what you actually heard them testify, I believe you'll notice that what Mr. Ross tells you connects. The DNA that was found on the front of this GMC Acadia. Here and here. This would be the front right of the vehicle. Where did Mr. Ross say that Devin Clark chased her with? Down the front right of the vehicle. That's where her DNA is. When we looked at the crime scene photos, Devin Clark's DNA was found in little blood spots that were on the ground on the left side of the vehicle. Where did Mr. Ross say he had his altercation with Mr. Clark? It was on the left, on the driver's side of the vehicle. Not like what Mr. Sykes said. His claim was that this altercation took place in the car, that there was a shot that went off in between Devin's legs, and that afterwards Mr. Ross turned around and shot Lyric. That would imply there would be bullets or shots in the car, that there would be blood DNA in the car. That did not happen. But that got clarified. When Mr. Ross got up on the witness stand, he did admit that he talked with Mr. Sykes. Now, what Mr. Sykes took from that story, I don't know if it was a bad case of telephone or if Mr. Sykes was embellishing. He was told by Mr. Ross, man, I almost lost my life last night. He even told him, I had to shoot him, talking about Devin. He told Mr. Sykes that Devin shot her, because at the time he didn't know her name. Now, what he took from it, I don't know, even to this day. Now, if we want to go further and talk about Mr. Ross's story, the state brought an expert from the FBI to talk about where everyone was that night. And we had their cell phones, and we triangulated every phone at every time. We had a big blow up of where the phones were at the beginning. It was marked by the petrol station, Isaiah's house, Devin's house, Lyric's house, and the crime scene. And it's clear where Devin's phone was when this incident first happened. How his phone moved after he got picked up and went to Lyric's house. It shows Isaiah's movement from his house to Devin's house, to Lyric's house, to the crime scene, to the gas station, back to the crime scene, and home. And when we're talking about the testimony, when we're talking about the evidence, I believe that the state's evidence supports what Mr. Ross said. The messages between Lyric and Devin. The fact that she was giving them the location to meet up. The fact that she was giving them instructions on how she can sneak out and not be detected. All within the confines of what Mr. Ross said. Everything. The dialogue that Devin Clark had prior to him even reaching out to this group chat and his statements to this individual starts out with, "Hell you doing, fool? NS gang," or GNG. "Trying to get 8? I think that's a TN exclamation point. Laugh emoji, laugh emoji. "By who?" LMAO, that bitch, Lyric. Dennis responds, "She said she'll eat us both." And the conversation goes on and on. And that is a description of how Devin was describing her before this altercation. And then after he was unable to acquire a ride from this individual, he then went to a group chat and he messaged this: "You on wheels? Who on wheels want free buns?" Basically, smiley face emoji. That is what put this plan in motion. That is what led to a crime scene on Buckhorn Road. The law enforcement arrived and found multiple shell casings and bodies on the ground. That is what led to the death of Larry Woods by Devin Clark. This was not planned. This was not intended. But you've heard the story. This is what happened. These two kids started the night thinking they were going to go out and have sex. And it turned out to be a situation that none of us will ever forget. But the question is, who did what? Devin Clark killed Lyric Woods. When the state was discussing the position of the bodies, one of the officers rolled Devin's body over, and underneath it was a crock. It was a Crocker shoe that belonged to Larry. Now, why is that important? Well, it shows the order of things. In order for Devin to be placed there, on top of that shoe, it would have to show that Lyric's shoe had to end up there first. We talked a little bit about this, but I want to make sure you saw. So this is kind of a timeline here. We had a Snapchat message. Isaiah picks up Devin after the Snapchat message. Devin has a book bag. clear, gets in shortly thereafter. That is when Devin points him in the direction of Buckhorn Road. Isaiah gets out the car, he asks, Devin, can I get your vape while you guys do what you do? And then there's the verbal altercation between Devin and Clear. They get out the car, Isaiah hears the commotion, and then everything happens so fast. Devin runs around the car, takes out his gun, and shoots her. Boom, 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 boom. When Devin points his gun at Isaiah, that is a key thing. That is where Isaiah, fear, adrenaline, fight or flight, takes this gun and does the only thing he thinks is possible. He shoots Devin, continues firing until he lays down or stops moving because that was his threat. He's panicking, he doesn't know what to do. Tries to get in his car, realizes he can't because the road was so narrow that he can't get around him. Picks up Devin, pulls him back, then he drives off. Can't even get home because his gas tank was on it before they ever even got there. Now, when you all are deliberating and going through all these facts and scenarios, remember that you individually are to think about what you recall, what you remember, about how you interpret all this information. And if you are in that room and there are elements that are presented to you by the judge on this jury instruction, and your answer to that question is maybe, I think, probably, then your response on your verdict sheet should be not guilty. But if you go through and you listen to or think about all the facts, looking at your notes, hearing about the conversation of your colleagues, and you are sure about all of these ideas, all of these elements, yes, that is guilty beyond a reasonable doubt. But I believe that when you really stop and think about all the things that you heard, minus the emotion and the shock of what you guys have all experienced and you saw, there will be doubt. There will be some uncertainty. There will be questions that are left unanswered. The only things we know for sure are that 3 people went to Buckhorn Road that night. 1 person left. 1 gun at scene. 1. And Devin Clark property. He used that gun to kill Larry Woods and to try and kill Issiah Ross. And the only way he could have made it out alive was by taking the gun from his cap. The only way. And I believe once you've gone through that analysis together, that you will find the verdict of not guilty of the murder of Devin Clark and the murder of Larry Woods. Thank you.
Mr. Trout? Thank you. Ms. Orr?
I got just another moment, Your Honor.
Yes, ma'am.
Thank you. Thank you, Your Honor.
No problem. Ms. Orr, the jury will be with you.
Thank you. On the afternoon of September 18th, 2022, two families' worst nightmares were cemented into reality when they found out that the bodies found on Buckhorn Road in Efland were the missing teenagers Lyric Woods and Devin Clark. This case is about a choice that ended two futures. Three young people got together in the early morning hours of September 17th, and now two of them are dead. Now, the defendant chose to testify, and that's his right. But he is not a neutral witness. He is the only person in this courtroom with a personal stake in your verdict. He has every reason to explain, to minimize, to justify. He told you what he needs you to believe, not what the physical evidence proves. And when his words conflict with the physical evidence, you are not required to accept his version. Stories can be shaped. Evidence cannot. And from the defendant's perspective, he has to somehow justify two killings, or he has to completely absolve himself of responsibility for one of them. It would be nearly impossible to justify those two close-range shots to Lyric's neck as being necessary in self-defense. But by saying Devin shot Lyric, he eliminates all possible responsibility for her death. And he puts in your minds that Devin was a threat to him, thereby justifying killing Devin in self-defense. Now that's a tidy argument if it was supported by the other evidence in the case, but it's not. First, the defendant claims that the first set of shots testified to by James Rogers was Devin shooting Lyric, and then the second set of shots was the defendant shooting Devin. Mr. Rogers testified that he was woken up by a noise, fireworks, or gunshots. He wasn't 100% sure. And then 10 minutes later, he heard 4, not 5, distinct gunshots. We know from the evidence that Devin was shot 6 times, not 4 times. Now, I'm no mathematician, but even I know that's not adding up. The defendant's testimony also does not account for that 10-minute gap at all He says everything happened so quickly, but that can't be right. Now, the defendant also testified that he threw all of Devin's belongings out of the car on the side of Buckhorn Road on the way to the Petro. But there are a few reasons why we know that can't be true. On the cash report, Devin has 61 timing advance records between 1:45 a.m. and 2:42 a.m. Roughly one per minute. And this block down here. And his phone never leaves the scene. All of those records are a consistent distance from this tower and the timing advance bands going right over the top of the crime scene. And the last time Devin's phone connects to the network is at 2:44 a.m. The defendant's phone, on the other hand, is on the scene from 1:45 a.m. to 2:14 a.m., and then it travels, and he heads to the Petro. And we know he's at the Petro from 2:20 to 2:29 a.m. Remember, the Petro video shows him approaching the cashier, and he's holding his phone in his hand. And the Petro video says this is from 2:11 to 2:19, but obviously that's 10 minutes slow because this timing is going to be the most accurate timing. And we know he's there. He's on video. Now, he returns to the scene at 2:36 a.m. And he's there until 2:50 a.m. Now, that encompasses the time frame that Devin's phone suddenly disconnects from the network. Additionally, Devin's vape, this vape that we keep hearing about. The defendant said on cross-examination this morning that that vape was in his pocket and that he threw it out with the rest of Devin's belongings. But the medical examiner testified, and it's in her report, that in the clothing and personal effects section, Devin's body was clad in tan pants, 2 black socks, black underpants, a black and white long sleeve hoodie and underlying white t-shirt. A vaping device is in the pants pocket. So if the defendant wasn't in possession of Devin's vape, Devin was in possession of Devin's vape. When did that happen? The defendant also testified that he moved Devin's body before heading to the Petro. He specifically said that Devin had fallen face down near the edge of the gravel and that he took off his camo jacket, removed his black quarter zip, used the quarter zip to flip Devin over so that he was face up, and then dragged him so he was completely out of the road. Now, the evidence shows that Devin lay bleeding face down for some period of time before he was turned over, and that he was right next to Lyric when this happened. Remember the crime scene photos, and we discussed the 2 large pools of blood that you can see in between the bodies, depicted here by Lyric's hip and here by her foot. Now imagine you took Devin and you rolled him over onto his face toward Lyric. Those 2 pools of blood would line up exactly with the thigh wound and with the wound to his shoulder. You rolled him over face down right there, that's where he's going to be bleeding. And because those pools of blood are so large, we know he had to have been left there for some time for that to accumulate. And remember also the dusty, dirty spots on his clothing, which were inconsistent with how he was found. Now, it took approximately 20 minutes for the defendant to drive to the Petro, get the gas, and then come back to the scene. And that would explain why those 2 areas of blood exist when they don't match up with any other injuries on either Lyric or Devin. The defendant also testified that he returned to the scene after leaving the Petro to retrieve his black quarter zip that he used to move Devin's body. Members of the jury, the defendant's wearing a black quarter zip at the Petro. You can see it here underneath the camo jacket. It's a little fuzzy, You can see this shine right here in the center of the neck, and you can just barely see right there a lighter spot where that zipper would end. So you can't have left it at the crime scene, which means he didn't use it to move Devin's body, which means there must be some other explanation for all of this. In jury selection, you describe some things that are important to you in determining the credibility of a witness and what weight to give their testimony. You describe things like whether they have provided consistent statements, whether they have an agenda, whether their story matches or lines up with other evidence, and also a person's demeanor and body language. Now, this is supposedly one of the most horrible things that's ever happened to the defendant, but his affect and delivery in this courtroom was completely flat. There was no emotion at all. The defendant failed all of the tests that you described, that you use in your everyday lives to assess someone's credibility. So now that we know that the defendant's story is a fabrication, the question remains, what exactly did happen in the early morning hours of September 17th? So let's talk about Christian. Issiah was not a suspect before Christian came forward. The sheriff's office had not yet uncovered any evidence connecting the defendant to the offense. Christian did not know his interview was being recorded, and he wished to remain anonymous. And it was pretty obvious that he did not want to be here testifying. So if Christian isn't being honest about his conversation, then he just, out of the blue, decided to implicate someone that he has a casual friendship with in a gruesome double homicide. He could have easily told the deputies when they called him that he didn't have any information and kept himself completely out of it. So why come forward unless the information is true? Issiah's testimony about his relationship with Christian contradicts itself. Yesterday on direct examination, he said that he and Thomas, Christian's cousin, had a falling out, but that he and Christian kept hanging out after that. That Christian would pick him up from work and give him rides, and he described that. And today he told you that he fell out with both of them at the same time, and that he had not spoken to Christian until Christian contacted him on that Sunday the 18th. In his testimony, Issiah did not tell you what he told Christian. He said he gave him a brief description, that it was not a complete recitation, that he told him what actually took place, but that he can't really say what he said to Christian. The version that the defendant told Christian is more plausible than what you heard from him on the stand. Issiah told Christian that I capped them, that they were both going to have sex with Lyric, but he didn't provide any details about what happened when they arrived to the scene. Then he said that Devin was beaming him with a gun. He told him to stop doing that once, twice, and on the third time, he was upset enough about it to try to wrestle the gun away from Devin. That the gun went off between his legs, that he got control of the gun and shot Devin, and then he turned around and shot Lyric because she was a witness. Now, Christian testified that he assumed that this occurred in a vehicle because of the phrase turned around, and also stated on the stand, on cross-examination, that Issiah never told him it happened in the car. That's just what he assumed. Now, turn around could mean a lot of things. I mean, if I'm facing this direction and I turn to face this direction, then I've turned around. And there's no evidence that there were any shots fired in the car. So although that was one assumption he made, he didn't actually say that that's what the defendant told him. Now, Christian also described that they had this conversation over video chat on Snapchat. And he said that Issiah was outside at his stepdad's house when this happened, which is consistent with where Issiah was on Sunday. He was at Antoine's house, and Antoine testified that he spent most of the day outside. And also remember how Christian described the defendant's demeanor. He was laughing, that he was joking. He didn't seem to have any remorse at all, while relating that he had just killed 2 people. And he told Christian all of this without prompting and before their bodies had ever been discovered. Now, it's equally important what he does not tell Christian. He doesn't say, I was scared for my life. He doesn't say, I was threatened. He doesn't say, I had no choice. He doesn't say it was either them or me. And he does not say that Devin shot Lyric. And Issiah confirmed that for you in his testimony. He did not tell Christian that Devin shot Lyric. Now, the version of events that Issiah told Christian bears almost no resemblance to his testimony at this trial. One of these statements was made within 48 hours of the events happening. One was made over 3 years later, after he's had an opportunity to review all of the evidence collected by law enforcement and hear all of the evidence presented in this courtroom. Which one is more likely to be closer to the truth? So, what does the evidence show us? The evidence shows that Devin and Lyric did have sex, or at least engaged in some kind of sexual contact. Lyric's oral swabs, her underwear, and her external genitalia swabs show both her and Devin's DNA. Devin's underwear and his external genitalia swabs show both his and Lyric's DNA. So something happened between them, most likely exactly what was discussed in the messages, oral sex. Now, the evidence shows that Devin was offering for whoever was going to give him a ride to have sex with Lyric. But there's no evidence that Lyric was aware of that promise or that she agreed to it. The defendant gave a ride under the impression that he would have a turn. Perhaps this is what sparked the disagreement. Lyric and Devin finished what they were doing. The defendant stepped up expecting his turn. And Lyric balked because that is not what she signed up for. Now, it's possible that Lyric did say what the defendant said, that she told Devin she wasn't a whore and she wasn't going to let Devin pimp her around. What if those statements were in reference to not having sex with the defendant? We can't know for sure. You know, there's this TV show on Netflix called Black Mirror. I don't know if any of you have seen it. But it's about the interesting intersections between technology and our real lives. In one episode, there's an implant that you can get that'll record every single thing that happens to you. Or kind of like those red flag replay commercials during football games, where you can just relive an event exactly as it happened. Well, we don't have that luxury. We don't have that technology. So we can't know for sure what happened. But something sparked a disagreement, such that a gun was introduced to this situation. We also can't know for sure who brought the gun or who introduced it to the conflict. That is not a knowable fact. What we do know is that the defendant walks away without a scratch, and that Devin and Lyric end up dead. Now, how could this have happened? How could this have happened? If we look at the crime scene photos, we sort of have 3 distinct areas. Shell casings down here that were marked 1, 2, and 3 by the sheriff's office. You know, there's no blood surrounding those rocks or anywhere near them. Perhaps those were the first shots fired. So we have 3 shots, and maybe we assume that those are the body shots that are front to back. So that would be Devin's right shoulder, Lyric's left arm just above the elbow, and Lyric's left shoulder that entered at an angle and then exited her upper arm, as if she were turning away from the person who was shooting. Now, if those injuries occurred next to the GMC on that front passenger side, that could explain her blood on that fender and the rim there. Now, both begin to move away, and they are moving up the scene toward where we have this row of placards back here, 7, 4, 18, 5. There are 5 shell casings found along that same path right there. Placards 4, 5, 6, 7, and then the one found the following day by investigator Vila, which he described as being over here just on the edge of this brushy area near where the red slides were located. Now, somewhere over here to the left, near placard 7, is where Devin receives his foot injury. And that shot was also slightly front to back, according to the medical examiner. So imagine he's moving away from where 1, 2, and 3 are. He's moving toward where 7 and 4 are. And then he realizes he's going to run into all this thick brush here. And so he has to change direction. He could have easily gotten that foot shot during that process. And that is consistent with the blood. It starts out just a little bit here by placard 18, and it gets thicker and more frequent as we move along the scene from left to right towards placard 8 and 9, which were those other rocks with the blood on them. He loses his shoes in that tall clump of grass just beside placard 9 where all this blood is going. And then we've got the shoes here in the brush. Maybe he's urging Lyric along ahead of him. The defendant's still shooting them from behind as they make their way toward that open field. Both are hit enough times that they fall. They're unable to keep going from their injuries. Now, if you're keeping count, that's 8 shell casings. So here's the break that Mr. Rogers described. Once the 2 of them have fallen and they don't appear to be getting back up, then there's a break in the action as the defendant tries to figure out his next steps. Because now he's in big trouble. He can't afford to leave them alive. And that's the conclusion he reaches in those 10 minutes. And so then we have the 4 shots that Mr. Rogers described here. Those distinct 4 were the insurance shots to make sure that they are dead. And those are the casings that were found in the grass near Lyric's head, originally marked as 12, 13, and 14, and then upon a second examination, number 20 was also located. Right here, just above where both bodies are found. Those shots are the 2 in Lyric's neck, the one in the back of Devin's head, and either entrance wound 1 or entrance wound 2 for Devin. Those are the 2 injuries. One came through the front of his neck, severed his jugular and carotid arteries, and one entered the back of his shoulder, and that's where that projectile stopped, just above his collarbone. The defendant cannot claim self-defense with regard to the death of Lyric Woods because he claims he did not shoot her at all. But the defendant has argued that he acted in self-defense with regard to Devin Clark. Self-defense requires that the defendant believe it was necessary to use deadly force against the victim in order to save the defendant from death or great bodily harm. It also requires that the circumstances as they appeared to the defendant at the time were sufficient to create such a belief in the mind of a person of ordinary firmness, or put another way, that the defendant's belief was reasonable, and that the defendant did not use excessive force. The backs of these victims tell you everything that you need to know. Fear runs away. It does not give chase. It is consistent with the evidence that the victims were moving away when they were being shot at. Both of them have multiple gunshot wounds to the back. Now, our courts have said that it is entirely unreasonable that a person of ordinary firmness would have considered the use of deadly force necessary to protect himself from an unarmed person who was running away from the scene. Once the gun is in the defendant's hands, there is no longer any danger to Once the gun is in his control, he can leave. He can call for help. But he doesn't do either of those things. Instead, he chases down Devin and Lyric. Then, after 10 minutes of consideration, he shoots Lyric and Devin while they lie on the ground, bleeding from the wounds he has already inflicted. This was not one shot fired in panic. Panic does not aim, and chaos does not explain accuracy. This was a series of choices. It was a choice to pull the trigger a second time, a third, a fourth, and a fifth, and a sixth, and a seventh, and an eighth. And then it's especially the 9th, 10th, 11th, and 12th. Shot after shot, decision after decision. Now, once he can be sure that they're dead, the defendant does leave the scene. He goes to the Petro, he puts gas in the car, and he still doesn't call for help. Then he returns to the scene, and why? Because Devin's phone is still there, and it contains evidence. So he had to go get it. To accomplish this, he had to move Devin's body, because Devin was face down, and his phone was in that front pants pocket. Now you can see in the photographs how Devin's front pocket is saturated in blood from that thigh wound. Remember the luminol reaction over the dome light in the car that appeared to be a handprint that was cleaned? Now we didn't have any confirmatory testing on that, but if it was cleaned, that's not necessarily unexpected. So imagine he fishes the phone out of Devin's bloody pocket, and then when he gets back in the car, he sticks his hand up there to cover that light to make sure he's not seen. The wicked flee when no man pursues. With Devin's phone secured, the defendant leaves, and the cover-up begins. He disposes of evidence. Devin's phone and the murder weapon have never been located. He covers his tracks with the messages in the group chat. First, that same night, he messages that he was asleep and couldn't get his mother's car to use, which by his own admission were untrue. Second, throughout the weekend, he's responding to messages about Devin being missing and then Devin being dead, as if he didn't know exactly what had happened to him. And then third, he makes arrangements to leave the state and he flees. It takes until October 5th for law enforcement to find him. 15 days between charges being taken out and his arrest. Now, the defendant was young, only 17 at the time of the offense. And while youth may explain immaturity, it does not excuse violence. At 17, the defendant was old enough to understand what a gun does. He was old enough to understand that pulling the trigger ends lives, and he was old enough to stop. His age does not change what happened, and it does not change your duty. In a few moments, the judge will instruct you on the law you must apply. For first-degree murder, the law requires the state to prove the following: that the defendant intentionally and with malice killed the victim, that the defendant's act was the proximate cause of the victim's death, that the defendant intended to kill the victim, and that the defendant acted with premeditation and deliberation. Malice means without just cause, excuse, or justification. Premeditation simply means the intent to kill was formed before the act. The law does not require a long time. In fact, mere seconds can suffice, as long as there was time to think. Deliberation means the act was carried out in a cool state of mind, not under a sudden, overwhelming passion. And you'll be instructed that you can infer premeditation and deliberation from the following circumstances: the lack of provocation by the victim, the conduct of the defendant before, during, and after the killing, the use of grossly excessive force, the infliction of lethal wounds after the victim is felled, the brutal or vicious circumstances of the killing, and the manner in which or means by which the killing was done. When you apply North Carolina's definition of first-degree murder to these facts, the conclusion is unavoidable. This was an intentional killing. There can be no other conclusion given the number of shots fired. It was done with malice, that is, without just cause, excuse, or justification. And premeditation and deliberation are shown by the repeated shots to the back, the additional shots fired after the victims had already fallen, and the defendant's conduct after the killing in trying to hide his responsibility. Under the instructions you'll receive, this was a first-degree murder. Each trigger pull, a separate decision to end a life. A 10-minute break in the action. Time to call for help. Who knows, that could have potentially saved the lives of Devin Clark and Lyric Woods. And then, the carefully considered decision to fire 4 more shots, silencing them forever. Stories change, evidence doesn't. The backs of these victims tell you everything you need to know. The wicked flee when no man pursues. 2 lives were ended. 2 families changed forever. They'll never graduate, they'll never grow older, and they'll never come home again. This courtroom is the only place where their voices can still be heard. The evidence is spoken, and now the law asks you to respond. Hold the defendant accountable for the choices he made and the lives he took. Return verdicts of guilty. Thank you.
All right. Ladies and gentlemen, before I give you the instructions, our wonderful court reporter has been working since 1:30. We need to give her a break before she has to type down everything I say. So we're going to take a 15-minute recess. Please remember all of the rules. Put your notebooks in your chairs. Ladies and gentlemen, stay seated in the courtroom. And we'll excuse our juror for a 15-minute break. Thank you. All right, all of our jurors are outside the courtroom. Anything we need to address before we take a break?
No, Your Honor.
No, Judge, just want to make sure we get all this back to the clerk.
Make sure Madam Clerk gets it. All right, we'll be in recess for 15 minutes.
Oh, I know, I came out this door in addition to that to actually. Who can we call if they need to get more to the cleaners, if they need to do paper? We're bad out of toilet paper. Also. So we need all the paper products. Toilet paper and why would I add maintenance needs to fix that water valve. Give it a good try.
Don't call me Shirley.
All right, I haven't heard that since Jeff Shirley.
Be seated, come to order, order back to session.
All right, anything we need to address before we bring the jury in?
No, Your Honor.
The defense, thank you, Judge.
All right, bring our jury back in, please. It's on, so. I don't think anybody's ever accused me of not talking loud enough. All right, we've got all of our folks back. Members of the jury, all of the evidence has been presented. It is now your duty to decide from this evidence what the facts are. You must then apply the law that I'm about to give you to those facts. It is absolutely necessary that you understand and apply the law as I give it to you, not as you think it is, and not how you might like it to be. This is important because justice requires that everyone tried for the same crime be treated in the same way and have the same law applied. The defendant has entered pleas of not guilty. The fact that the defendant has been charged is no evidence of guilt. Under our system of justice, when a defendant pleads not guilty, the defendant is not required to prove the defendant's innocence. The defendant is presumed innocent. The state must prove to you that the defendant is guilty beyond a reasonable doubt. A reasonable doubt is a doubt that is based on reason and common sense, arising out of some or all of the evidence that has been presented, or the lack of the insufficiency of the evidence as the case may be. Proof beyond a reasonable doubt fully satisfies or entirely convinces you of the defendant's guilt. You are the sole judges of the believability of the witnesses. You must decide for yourselves whether to believe the testimony of any witness. You may believe all, any part, or none of a witness's testimony. In deciding whether to believe a witness, you should use the same test for truthfulness that you use in your everyday lives. Among other things, these tests may include the opportunity of the witness to see, hear, know, or remember the facts or occurrences about which the witness testified, the manner and appearance of the witness, any interest, bias, prejudice, or partiality the witness may have, the apparent understanding and fairness of the witness, whether the testimony is reasonable, and whether the testimony is consistent with other believable evidence in the case. You are also the sole judges of the weight to be given any evidence. If you decide that certain evidence is believable, you must then determine the importance of that evidence in light of all other believable evidence in the case. There are two types of evidence from which you may find the truth as to the facts of a case: direct or circumstantial evidence. Direct evidence is testimony of one who asserts actual knowledge of a fact, such as an eyewitness. Circumstantial evidence is a proof of a chain or group of facts and circumstances indicating the guilt or innocence of the defendant. The law makes no distinction between the weight to be given either direct or circumstantial evidence, nor is a greater degree of certainty required of circumstantial evidence than of direct evidence. You should weigh all of the evidence in the case. After weighing all of the evidence, if you are not convinced of the guilt of the defendant beyond a reasonable doubt, you must find the defendant not guilty. A diagram was introduced into evidence in this case for the purpose of illustrating and explaining the testimony of a witness. This diagram may not be considered by you for any other purpose. Photographs and videos were introduced into evidence in this case. These photographs and videos may be considered by you as evidence of the facts they illustrate or show. Proof of motive for a crime is permissible and often valuable, but never essential for conviction. If you are convinced beyond a reasonable doubt that the defendant committed the crime, the presence or absence of motive is immaterial. Motive may be shown by facts surrounding the act if they support a reasonable inference of motive. When thus proved, motive becomes a circumstance to be considered by you. The absence of motive is equally a circumstance to be considered on the side of innocence. You may find that a witness is interested in the outcome of this trial. You may take that witness's interest into account in deciding whether to believe the witness. If you believe the testimony of a witness in whole or in part, you should treat what you believe the same as you would any other believable evidence. The state and the defendant, Issiah Ross, have agreed or stipulated that certain facts shall be accepted by you as true without further proof. The agreed upon facts in this case are as follows. State's Exhibit 128 is an authentic copy of subscriber information, communications content, and transactional metadata for Snapchat app account for subscriber identifier basketball_1296. Subscriber identifier basketball_1296 belonged to Devin Clark. State's Exhibit number 134 is an authentic copy of historical cell site location information and subscriber information for phone number 243-244-0344. Phone number 743-244-0344 belonged to Devin Clark at the time of the offense. State's Exhibit number 136 is an accurate copy of historical cell site location information and subscriber information for phone number 908-440-5523. Phone number 908-440-5523 belonged to Issiah Ross at the time of the offense. State's Exhibit number 138 is an authentic copy of surveillance video from the Petro Travel Center located at 500 Buckhorn Road in Mebane, North Carolina, 27302. Since the parties have so agreed, you are to take these facts as true for the purposes in this case. In this case, you have heard testimony from witnesses who have testified as expert witnesses. An expert witness is permitted to testify in the form of an opinion in a field where the witness purports to have specialized skill or knowledge. As I have instructed you, you are the sole judges of the credibility of each witness and the weight to be given to the testimony of each witness. In making this determination as to the testimony of an expert witness, you should consider, in addition to all the other tests of credibility and weight, the witness's training, qualifications, and experience or lack thereof, the reasons, if any, given for the opinion, whether the opinion is supported by facts that you find from the evidence, whether the opinion is reasonable, and whether it is consistent with other believable evidence in the case. You should consider the opinion of an expert witness, but you are not bound by it. In other words, you are not required to accept an expert witness's opinion to the exclusion of facts and circumstances disclosed by other testimony. If you find from the evidence that the defendant has admitted a fact relating to the crime charged in this case, then you should consider all of the circumstances under which it was made in determining whether it was a truthful admission and the weight you will give to it. Evidence has been received tending to show that at an earlier time, a witness made a statement which may conflict or be consistent with the testimony of the witness at this trial. You must not consider such earlier statement as evidence of the truth of what was said at the earlier time because it was not made under oath at this trial. If you believe the earlier statement was made and that it conflicts or is consistent with the testimony of the witness at this trial, you may consider this and all other facts and circumstances bearing upon the witness's truthfulness in deciding whether you will believe or disbelieve the witness's testimony. The state contends and the defendant denies that the defendant made false, contradictory, or conflicting statements. If you find the defendant made such statements, they may be considered by you as a circumstance tending to reflect the mental process of a person possessed of a guilty conscience, seeking to divert suspicion or to exculpate the person. And you should consider that evidence along with all other believable evidence in this case. However, if you find the defendant made such statements, they do not create a presumption of guilt, and such evidence standing alone is not sufficient to establish guilt. Such evidence may not be considered as tending to show premeditation and deliberation. The defendant has been charged with first-degree murder of Lyric Woods. Under the law and the evidence in this case, it is your duty to return one of the following verdicts: guilty of first-degree murder or not guilty. First-degree murder is the unlawful killing of a human being with malice and with premeditation and deliberation. For you to find the defendant guilty of the first-degree murder of Lyric Woods, the state must prove 5 things beyond a reasonable doubt. First, that the defendant intentionally and with malice killed the victim, Lyric Woods, with a deadly weapon. Malice means not only hatred, ill will, or spite, as it is ordinarily understood, but it also means the condition of mind which prompts a person to intentionally take the life of another, or to intentionally inflict serious bodily harm that proximately results in another person's death without just cause, excuse, or justification. The state proves beyond a reasonable doubt or is admitted that the defendant intentionally killed the victim with a deadly weapon or intentionally inflicted a wound upon the deceased with a deadly weapon that proximately caused the victim's death. You may infer first that the killing was unlawful, and second, that it was done with malice, but you are not compelled to do so. You may consider this along with all other facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. A firearm is a deadly weapon. Second, the state must prove that the defendant's act was a proximate cause of the victim Lyric Woods' death. Proximate cause is a real cause, a cause without which the victim's death would not have occurred, and one that a reasonably careful and prudent person could foresee would probably produce such injury or some similar injurious result. Third, that the defendant intended to kill the victim, Lyric Woods. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proven by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the assault, the manner in which the assault was made, the conduct of the parties, and any other relevant circumstances. Fourth, that the defendant acted with premeditation. That is, that the defendant formed the intent to kill the victim, Lyric Woods, over some period of time, however short, before the defendant acted. Fifth, that the defendant acted with deliberation, which means that the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible of direct proof. They may be proved by circumstances from which they may be inferred, such as a lack of provocation by the victim, conduct of the defendant before, during, and after the killing, use of excessively or grossly excessive force, infliction of lethal wounds after the victim is felled, manner in which or means by which the killing was done. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant, acting with malice, killed the victim, Lyric Woods, with a deadly weapon, thereby approximately causing the victim's death, that the defendant intended to kill the victim, and that the defendant acted after premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder. However, if you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. The defendant has been charged with the first-degree murder of Devin Clark. Under the law and the evidence in this case, it is your duty to return one of the following verdicts: guilty of first-degree murder, guilty of second-degree murder, guilty of voluntary manslaughter, or not guilty. First-degree murder is the unlawful killing of a human being with malice and with premeditation and deliberation. Second-degree murder is the unlawful killing of a human being with malice, but without premeditation and deliberation. Voluntary manslaughter is the unlawful killing of a human being without malice and without premeditation and deliberation. The defendant would be excused of first-degree murder and second-degree murder on the ground of self-defense if, first, the defendant believed it was necessary to use deadly force against the victim, Devin Clark, in order to save the defendant from death or great bodily harm. Second, the circumstances as they appeared to the defendant at the time were sufficient to create a belief in the mind of a person of ordinary firmness. In determining the reasonableness of the defendant's belief, you should consider the circumstances as you find them to have existed from the evidence, including the size, age, and strength of the defendant as compared to the victim, Devin Clark, the fierceness of the assault, if any, upon the defendant, and whether the victim had a weapon in the victim's possession. The defendant would not be guilty of any murder or manslaughter if the defendant acted in self-defense and if the defendant did not use excessive force under the circumstances. A defendant does not have the right to use excessive force. A defendant uses excessive force if the defendant uses more force than reasonably appeared to the defendant to be necessary at the time of the killing. It is for you, the jury, to determine the reasonableness of the force used by the defendant under all the circumstances as they appeared to the defendant at the time. Therefore, in order for you to find the defendant guilty of first-degree murder or second-degree murder of Devin Clark, the state must prove beyond a reasonable doubt, among other things, that the defendant did not act in self-defense. If the state fails to prove that the defendant did not act in self-defense, you may not convict the defendant of either first or second-degree murder. However, you may convict the defendant of voluntary manslaughter if the state proves that the defendant used excessive force. For you to find the defendant guilty of first-degree murder, the state must prove 6 things beyond a reasonable doubt. First, that the defendant intentionally and with malice killed the victim, Devin Clark, with a deadly weapon. Malice means not only hatred, ill will, or spite, as it is ordinarily understood, but it also means the condition of mind which prompts a person to intentionally take the life of another or to intentionally inflict serious bodily harm that proximately results in another person's death without just cause, excuse, or justification. If the state proves beyond a reasonable doubt, or it is admitted that the defendant intentionally killed the victim with a deadly weapon or intentionally inflicted a wound upon the deceased with a deadly weapon which proximately caused the victim's death, you may infer, first, that the killing was unlawful, and second, that it was done with malice, but you are not compelled to do so. You may consider this along with all other facts and circumstances in determining whether the killing was unlawful and whether it was done with malice. A firearm is a deadly weapon. Second, the state must prove that the defendant's act was a proximate cause of the victim Devin Clark's death. Proximate cause is a real cause, a cause without which the victim's death would not have occurred, and one that a reasonably careful and prudent person could foresee would produce such an injury or some similar injurious result. Third, that the defendant intended to kill the victim. Intent is a mental attitude seldom provable by direct evidence. It must ordinarily be proven by circumstances from which it may be inferred. An intent to kill may be inferred from the nature of the assault, the manner in which the assault was made, the conduct of the parties, and any other relevant circumstances. Fourth, that the defendant acted with premeditation. That is, that the defendant formed the intent to kill the victim, Devin Clark, over some period of time, however short, before the defendant acted. Fifth, that the defendant acted with deliberation, which means the defendant acted while the defendant was in a cool state of mind. This does not mean that there had to be a total absence of passion or emotion. If the intent to kill was formed with a fixed purpose, not under the influence of some suddenly aroused violent passion, it is immaterial that the defendant was in a state of passion or excited when the intent was carried into effect. Neither premeditation nor deliberation is usually susceptible of direct proof. This may be proved by circumstances from which they may be inferred, such as the lack of provocation by the victim, conduct of the defendant before, during, and after the killing, use of grossly excessive force, infliction of lethal wounds after the victim is felled, brutal or vicious circumstances of the killing, manner in which or means by which the killing was done. And sixth, that the defendant did not act in self-defense. Second-degree murder differs from first-degree murder in that the state does not have to prove specific intent to kill, premeditation, or deliberation. For you to find the defendant guilty of second-degree murder, the state must prove beyond a reasonable doubt that the defendant unlawfully, intentionally, and with malice wounded the victim, Devin Clark, with a deadly weapon, approximately causing the victim's death. The state must also prove that the defendant did not act in self-defense. For you to find the defendant guilty of voluntary manslaughter, the state must prove three things beyond a reasonable doubt. First, the defendant killed the victim, Devin Clark, by an intentional and unlawful act. Second, that the defendant's act was a proximate cause of the victim, Devin Clark's death. A proximate cause is a real cause, a cause without which the victim's death would not have occurred. And third, that the defendant did not act in self-defense or, though acting in self-defense, used excessive force. Voluntary manslaughter is also committed if the defendant kills in self-defense but uses excessive force under the circumstances. The burden is on the state to prove beyond a reasonable doubt that the defendant did not act in self-defense. However, if the state proves beyond a reasonable doubt that the defendant, though otherwise acting in self-defense, used excessive force, the defendant would be guilty of voluntary manslaughter. If you find from the evidence beyond a reasonable doubt that on or about the alleged date the defendant, acting with malice and not in self-defense, killed the victim, Devin Clark, with a deadly weapon, thereby proximately causing the victim's death, that the defendant intended to kill the victim, Devin Clark, and that the defendant acted after premeditation and with deliberation, it would be your duty to return a verdict of guilty of first-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of first-degree murder, but then will determine whether the defendant is guilty of second-degree murder. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally and with malice, but not in self-defense, killed the victim, Devin Clark, with a deadly weapon, thereby proximately causing the victim's death, it would be your duty to return a verdict of guilty of second-degree murder. If you do not so find or have a reasonable doubt as to one or more of these things, you will not return a verdict of guilty of second-degree murder, but then will determine whether the defendant is guilty of voluntary manslaughter. If you find from the evidence beyond a reasonable doubt that on or about the alleged date, the defendant intentionally wounded the victim, Devin Clark, with a deadly weapon, and thereby proximately caused the victim's death, and used excessive force, it would be your duty to find the defendant guilty of voluntary manslaughter, even if the state has failed to prove that the defendant did not act in self-defense. However, if you do not so find or have a reasonable doubt as to one or more of these things, it would be your duty to return a verdict of not guilty. And finally, if the state has failed to satisfy you beyond a reasonable doubt that the defendant did not act in self-defense or that the defendant used excessive force, then the defendant's action would be justified by self-defense, and it would be your duty to return a verdict of not guilty. Members of the jury, you have heard the evidence and the arguments of counsel. If your recollection of the evidence differs from that of the attorneys, you are to rely solely upon your recollections. Your duty is to remember the evidence, whether it is called to your attention or not. You should consider all of the evidence, the arguments, contentions, and positions urged by the attorneys, and any other contention that arises from the evidence. The law requires that the presiding judge is to be impartial. You should not infer from anything I have done or said that evidence is to be believed or disbelieved, that a fact has been proved, or what your findings ought to be. It is your duty to find the facts and to render a verdict reflecting the truth. All 12 of you must agree to your verdict. You cannot reach a verdict by majority vote. When you have agreed upon unanimous verdicts as to each charge, your foreperson should so indicate on the verdict forms. After reaching the jury room, your first order of business is to select your foreperson. You may begin your deliberations when the bailiff delivers the verdict forms to you. Your foreperson should lead the deliberations. When you have unanimously agreed upon a verdict as to each charge and are ready to announce them, your foreperson should record your verdicts, date and sign the verdict forms, and notify the bailiff by knocking on the door or however else you've been letting them know that you're ready. And you'll be returned to the courtroom and your verdict will be announced. Thank you. So, first thing you're going to do is you're going to go back and you're going to pick who your foreperson is. You're going to let the bailiff know that you have done that, and we're going to send back this very official envelope. Inside this envelope will be 2 verdict forms, copy of the instructions I just gave you, and a notepad to write down if you have any questions or concerns. All right? I have my 3 alternates. You must stay with us because your Tom Brady moment may still arise. And so what we're going to do is first I'm going to have you just stay here in the courtroom for a moment while we excuse the first 12. And then we're going to take the 3 of you and you're going to have a place you're going to be able to go to hang out. You are kind of in a different situation in that you still are kind of in your jury bubble. So don't talk amongst yourselves about the case yet. If for some reason you are called in to take a place of one of our 12 jurors here, I'll give you some additional instructions to everybody about how to proceed at that point, but that's nothing hopefully we're going to have to worry about at all. All right? So you get to take your notebooks with you, so you don't have to leave them in your chair. So I'm going to ask everybody else to please remain seated. First, let's take our first 12 jurors, and then if we'll take our 3 alternates. So my first 12, if you please follow the bailiff out. Let us know when you have picked your foreperson. And do we have somewhere we can put our 3 alternates? All right, we'll let our 3 alternates head out to your alternate place. You can take them with you. All right, all of our jurors are outside the courtroom at this time. Are there any requests for corrections or changes to the jury instructions from the state,
No, Your Honor.
from the defense?
No, thank you, Judge.
All right, we will print off the final copy for the jury and put that in with the verdict form and notepad. I plan on allowing the jury to continue to deliberate until 5. And unless they give some indication that they are right at making a decision, I'm going to let them go home at 5 and have them come back tomorrow morning. Is there anything else that either one of you want to address at this time?
Not for the state.
In the event that the jury asks to see a piece of evidence, I didn't know what the court's opinion is on that. Go ahead, Judge.
Yeah, let's wait to see what they want, and then we'll put on the record how everybody feels about that. If they want to watch video, typically we have them come back in. If they want biological evidence, we can have a conversation about whether that goes back with them or whether we bring them into the courtroom. And then we can deal with photos, and those are usually pretty easy to send back if everybody agrees.
Yes, Judge.
All right. They picked. All right. The jury has picked a 4-person, so I am going to send the verdict form, copy of the instructions, a notepad, and an official state pen to go back to our jurors and allow them to begin their deliberations. Thank you, sir. All right. We're going to be at ease, but there are a couple rules. First is I need the attorneys to always let Madam Clerk know where you're going to be at in case the jurors come back with a question. So do not wander far. All right. Number 2, although we're going to be at ease, I'm just going to ask everybody in the courtroom if you have, so let's keep the noise down since we're still technically in session. So if you have to have a long conversation, I just ask that you step outside into the hall to have that conversation. Anything else?
No, Your Honor.
No, thank you, Judge.
All right, we'll be at ease until such time as we need to address them. come on up. Thank you. All right. We have, do I have everybody here? I have everybody here. All right. We have a note from the jurors. Actually, it's a number of questions, so let me read them to everybody, and then we will go through. I will mark this as Courts Exhibit number 1. All right. Requests of the jury. 1, it's not numbered number 1, it just has a little dot. We would like a whiteboard or pad of paper on a stand. Second one written down is crime scene photos. Third line is Christian Sykes testimony on video. Fourth is video of petrol station. And fifth is cell phone data. Then question, do we have hard stop at 5? And last question, what time do we start tomorrow? All right. So, do we have somewhere in the courthouse a whiteboard?
The whiteboard that I use is in the back room. It was never touched, and it belongs to the courtroom itself.
I know I am old, so I will say old things. Back when I was a DA, aside from walking uphill in the snow both ways, we used to have like the flip chart pads. Do you guys have that?
There used to be one in the closet back there. I don't know if it's still there. I think it may have gotten used up, and I'm not sure we've resupplied. We may have one in our office, but we're finding out.
Thank you. Because we may send both back to them. If not today, maybe tomorrow. So let me know when your folks have checked on that, and I appreciate entertaining that.
Yes, Your Honor.
All right. We'll need to erase the whiteboard before it goes back.
Oh, that right before I was referring to never got written on. It was the one I set up there, but never actually wrote on.
Oh, okay.
Yes,
All
ma'am.
right. Is that yours?
No, ma'am. It was already here.
Okay. All right.
We do have a large flip chart thing.
Yes. I have no idea what the official name of that is. All right. All right. So, does anybody have any objection to sending back the whiteboard and the flip pad with them?
No objection from the defense.
No objection, Your Honor.
All right. Second thing, any objection to sending, and they only ask for the crime scene photos. Is there any objection to sending those back with the jurors?
No objection from the state.
The alternative is, if there is, we'll bring them in and let them go through them here in the courtroom.
I think for expediency's sake, maybe letting it go back there is okay. I've had an issue with it in the past, and so I think they may move a little faster if they do it here, whereas if it goes back there, that sometimes prolongs things. So that obviously it's up to the court's discretion, but
Actually, it's up to you. If you don't object, then it's up to me.
well, this time I will object, so you can make the decision.
Well, no, if you object, then the only alternative is they have to see them in the courtroom.
Yes, I would prefer that. I believe that would be the most effective way of doing
Okay.
it.
The third, Christian Sykes testimony on video, the only way I think that we can handle that is have them come in and replay that
Yes, Your Honor.
for them. The same for the video of the petrol station. The cell phone data, is there any objection to sending the cell phone data? I will clarify if they want the raw data or whether they're asking for the FBI analysis and/or. But is there any objection to sending that back with them?
No, Judge.
I assume they want the cast report PDF. The raw data is on a disk, and so unless they have a means of looking at it, it also doesn't mean much without interpretation.
We'll see what they want, and then we can decide. All right. Do we have to stop at 5? Yes. Unless they are like, we're 15, 20 minutes from reaching a decision, we're going to let them go home tonight. And what time do we start tomorrow? Unless there's a request, we usually just start at 9:30. That gives district court a time to sort of clear out a little bit before we have everybody coming back to our courtroom.
We have no district court tomorrow, and I don't know if they're concerned about the potential weather coming in over the weekend and wanting to make sure they have sufficient.
We can start at
Time.
9.
I would be fine with that, Your Honor.
9 is fine, but when I looked at the weather, I don't think we're getting anything until later after we leave, so.
So before we bring the jury in, let's just talk really briefly about this. So I do not want the possibility of either 2 flakes or the storm of the century, who knows, occurring. So the general plan is we will excuse them at 5. I anticipate if the storm is anything like what is predicted, we will not be here Monday. We're going to arrange with the clerk's office to get their emails and then individually email them if they need to be present on Monday or on Tuesday.
Yes, ma'am.
That way, they will not have to be dependent on trying to catch it on the news or whatever, since we're trying to keep them away from the news, not because that isn't awesome, but just because we don't want any problems with that. We will figure out between us here in the courtroom, between the bailiffs, you all, me, how we'll keep each other informed.
Yes, ma'am. But as for the question of start time, if there's no issue with district court, we can all be here at 9 o'clock to get things going,
Yes, I will love it.
especially if we have to sit and watch a bunch of video.
I think there's actually 3 courtrooms running tomorrow.
Oh,
What-
I got child support, civil, and small claims.
So that won't even be as big as one regular district court docket, though.
That's true.
do we have enough personnel with the bailiffs to be able to cover?
Yeah.
Okay, all right. All right, without any, all right. Seems like everybody is okay with being here at 9, so let's go ahead and get them in and let them start early. if that's
Yes, Your
okay.
Honor.
All right, so here are my answers to the jury's requests. We'll get them a whiteboard and a pad of paper with the stand so that they can take that back and use whatever they want to. 2, we're going to allow them to see the crime scene photos here in court tomorrow. We'll let them listen to Mr. Sykes' testimony on video tomorrow. We'll let them watch the video of the petrol station. I'm going to clarify what they mean by cell phone data. I am also assuming they want the FBI CAS report. If that's true, we'll send back the printed copies that were entered into evidence. And Madam DA, if you find out what number that is, or Madam Clerk, somebody get me an actual number.
I'm pretty sure it's 144.
And we don't have to do this right now.
It's 144.
Excellent. Find me the crime scene photo number so we can agree.
2 through 32.
That's correct.
Well, if you're going to be like that. All right. Sounds good. Anything else that you want to address or put on the record before we bring our jury back? I plan on answering the questions and then sending them home.
Nothing for me, Your Honor. Thank you.
Nothing from the defense. Thank you, Judge.
Keep our alternates until after I answer the questions, and then I'll have them come in and we'll excuse them. Please. I think I know, but who is the foreperson on this jury? Stand up. Mr. Marini? Marini. Mr. Marini. I am not shocked. So, Ms. Marini, I received a note that I think you sent to me with a number of questions. So I want to answer them in the order you sent them. First, we would like a whiteboard or a pad of paper on a stand. We're going to get you both. You can use whichever one or in conjunction, however you all need it. All right. Number two, the crime scene photos, which are states 2 through 32, we're going to have you look at here in the courtroom. Number three, Mr. Sykes' testimony, we'll play that for you tomorrow here in the courtroom as well as the video from the petrol station. All right. So I have to ask a clarification. When you say cell phone data, that
Those diagrams that show where each phone was over the course of time.
that would be the FBI cast report? Yes, we will get that, and you may take that back into the jury room with you. Do you have to stop by 5? So here's my lawyer answer. Since you have a lawyer as your foreperson, he can interpret as necessary, all right? If you are close to, say, reaching a decision, and you say to me, we need 30 minutes, we need an hour, and we feel like we're at a position where we will reach a decision, I would agree to allow you to stay past 5. I am impressed that you all are so hardworking. You're already asking that question. But as you can see, I have a lot of court personnel that help assist in making sure this can all happen and happen safely. And I need to also take into account their families. So, and if it's, I usually don't go past 5 for y'all, but also just for everybody else. So if it's something that you need in order to reach the goal line, we can adjust. But if it's just because you're so hardworking and amazing, I'm just going to have you come back the next day. All right? In light of that, though, unless you all wanted to start later than usual, I was going to see if we couldn't start a little earlier. Would that be about what y'all want to do? That's it. So what we'll do, we'll get to that whiteboard and paper for tomorrow. I'll have them put it back in the jury room for you. We'll bring you in first thing in the morning, pass around the crime scene photos. We'll then play Mr. Sykes' video, and then we'll play the video from the petrol station. And then we'll send the cell phone data, which is states 144, back with you. You now kind of have an idea about stopping time and when we're going to start tomorrow. You all are fabulous. And I want you to know this is a lot. We will take however much time we need to. You need to take however much time you need to. There's no clock ticking. I know you all have lives and jobs and things you want to get back to, but this is incredibly important, and you all have shown that you know that. So we will do, there's no rush. We'll be here. We'll make sure you all are okay until we get to that point where you all have reached the decision. All right? So I appreciate an amazing, hardworking attitude. I am going to let you all go home tonight because I don't think the answer is we're close to reaching a decision since you asked to look at some other evidence. What I'm going to ask you to do, if y'all don't mind, just sit here for a minute so I can, and you can go ahead and have a seat. I'm sorry. We're going to bring the alternates back so I can give you all of those amazing instructions again before I excuse everybody. So if we could bring our alternate folks back in, please.
Your Honor.
Yes. Oh, yeah, that'd be a good idea. Ms. Marini, we'll collect the verdict packet. And I'll have y'all leave your notepads in your chairs tonight because you're going to come back in here in the morning. So. I'm not sure where they are, so we'll just hang tight till they get here. Apparently, we keep them way far away from you all. I think they're still in the building, though, so we should be all right. All right, we have reacquired our alternates from whatever secret place we're keeping you. So just to my 3 alternates, thank you for being here. So your hardworking other 12 are so dedicated, they would like to start at 9 tomorrow morning. And since we don't have any district court, we can do that. Are you 3 okay with coming back at 9? Excellent. All right, so we are going to recess for the day. So I have to tell you all the rules again that you already know, but I have to make sure you haven't forgotten them in the interim. 1, remember, totally hang out tonight. Normally this would be Thursday night football, but there is none, so I don't know why you would get together. But if you do, remember you can talk about anything you want, just not talk about this case with each other. That can only happen with my 12 folks when you're back in the jury room with your super fancy verdict envelope, all right? Number 2, you go home. Remember, you can't talk to anybody else about this. You can only tell them you're in jury deliberations in this murder trial. Don't talk to anybody online. Don't talk to any of your neighbors. 3, remember, stay away from any publicity about this. Don't let anybody talk to you or around you about that. Just excuse yourself or tell them to go to the garage or whatever you need to do. In addition, no independent research. No AI, no Google, no whatever amazing things are out there, including those encyclopedias. I know you're dying to find some. All right. In addition to that, please remember, well, you don't have to keep your minds open anymore, but you can't talk about it. So don't talk about how your minds are until you all get together tomorrow and you start going over everything. All right. We're going to start back here in the jury room. And I probably have the 3 alternates. We're going to do a couple things and probably have you go to your, I don't even know where y'all are. Apparently it's 7 miles from here. But we'll send you to whatever secret place we have you as soon as everybody gets here in the morning. So if everybody, you can be back in the jury room, and you can go with them in the jury room until we bring you in and then separate out, okay? Because we still love them, right? Even though they're the alternates, okay? All right. With that, I'm going to have everybody leave your notepads and your notepads in your chairs. We'll get them and get them back to you tomorrow morning. Everybody else, please remain seated. At this time, we'll excuse our jury to 9 a.m. tomorrow morning. All right, all of our folks are outside of the courtroom. Anything we need to address on behalf of the state,
No, Your Honor.
on behalf of the defense?
No, Judge, thank you very much for asking.
Mr. Trapp, you doing all right?
Yeah, just.
I know.
My wife sent me a message saying the test went well, so just checking on that.
Well, and, you know, she's got to have something to keep her mind up. We're certainly trying to take care of that for her. All right, we'll see everybody back here tomorrow morning. We will start at 9 a.m. I would ask that the attorneys come back. I just want to talk briefly about the storm of the century and some of my thoughts on how we're going to handle that. All right? All right, everybody else, have a good, safe evening. We'll be back here at 9 a.m. tomorrow morning.